It's processing my request to broadcast. Yes, we are live on YouTube now. Wonderful.
Okay,
so
cool.
Yeah. Okay, so this is a seminar series on law and philosophy. We got today Dan Priel from York University in Canada. And this is brought to you by the graduate schools of UFMG, Federal University of Minas Gerais, Federal University of Pará, Federal University of Paraná, and the University of São Paulo, okay? So then we'll speak today about making sense of nonsense jurisprudence. We circulated the paper before. It has been posted as at SSRN. And I will just invite Dan, thanking him for coming, for sharing his work with us. And I hope that we have a very nice session. And it's wonderful to have Dan with us. Even though we have this difficulty, it cannot be in person. I'm very glad that we will be able to have a nice conversation about this interesting topic. Dan, go ahead. Thank you very much.
Thank you, Thomas. Thanks very much for inviting me. Thanks everyone for coming, especially for those who are kind of, it's an unusual time of the day or night. So this is a paper that in some respects I've been working on for a long time. I first presented it in the Dworkin conference in Canada 6 years ago, and I kind of didn't do much with it till recently. I had a conversation with a friend, and it kind of made me think that I should do something about it. In the course of doing this, I had a look at my previous version, and it was half the length. So you may regret that I didn't just give you that one, but the older one. But I think the main argument has remained the same. And it's an attempt, well, to make sense of Dworkin. The nonsense jurisprudence is, of course, a reference to Brian Leiter, who called Dworkin's work nonsense jurisprudence. And I thought, well, that makes a kind of a bit of a lame pun to call my paper making sense of nonsense jurisprudence. So I did that. There's an apology here. There's another one that's not on the slide, which I'm going to mention, but there's one that I feel obliged to say every time I speak before a kind of non-common law or non-Anglo-American audience, which is that we, or at least I, are very ignorant. So in the sense that my sense is that we in the English-speaking world know at best what people in the English-speaking world do, but only when you see some works of people from outside of that small world, you realize that there's a lot more out there, much of it not in English, but we don't speak those other languages. And even if it is in English, we don't really often read it. So what I'm going to say about sort of mainstream view within legal philosophy, you may say, oh, there's a ton of people who disagree with you. So I have to kind of always think about this as me saying English speaking or legal philosophers from the English-speaking world. So that's one caveat that I have to say. The other one is that, so the paper I sent to Thomas was not in good shape in terms of typos and other stuff. So I put now a version on SSRN, which is better. I'm pretty sure I will still need to make some changes to it, but apologies to those of you who have read the original version that was distributed because it was not in kind of super presentable shape. So that's it as far as introductions. Now to the topic itself. And so I did this presentation very quickly, and you can see I should have removed the title, content, layout, and so on. So I'm going to speak about three sort of subtopics. Why this paper matters for me. So which is goes beyond actually a little bit about what I say in the paper, but I want to explain how this paper kind of fits within my project overall, because maybe, I don't know, maybe it may have puzzled you that I, who consider myself a kind of hardcore naturalist, will come in defense of and be interested in the work of Dworkin. So that's one thing that I do want to talk about. It's not so much kind of hinted in the paper, but I want to say a bit more about this. Second, I want to speak about the sort of the main part of the paper, which is my kind of reconstruction of Dworkin. And then there's a third part, which I didn't ask you to read, but it is in the paper, which is sort of less jurisprudence, more history of ideas, which is me kind of trying to place Dworkin within the history of jurisprudence. And I think that's quite interesting. I'm personally quite interested in history of ideas. And I think that much of philosophy and legal philosophy loses by not taking interest in sort of the history of ideas. So if we have time, I'm going to speak a little bit about this. Even if I don't, so even if I stop and don't speak about that third part, but you have read that part and you have questions about it, I'm more than happy to try and answer questions about that. So even if I don't speak about this now, it's sort of fair game to ask me. Okay, so first, why it matters. So in the paper, I said, well, it matters not, the very least reason why it matters is because Dworkin, like it or not, is a significant figure within jurisprudence. And that's true as far as it goes. He is still kind of widely discussed, widely cited. I kind of did a search of how many articles have Dworkin in their title in Hein Online in the last 15 years. And I think I say there's 145 pieces that I found, which is an indication of interest in his work. But that's maybe not enough, especially since many legal philosophers tell us that he's really not really worth the time because he was a very bad philosopher, some people tell us. So I want to explain how his project fits within mine, and so kind of why I'm interested. And so my provocative, perhaps, starting point is what do legal positivists get wrong? And the short answer is they get everything wrong. And by legal positivists, I mean contemporary legal positivists. I distinguish, by which I mean Hart, Raz, and Go, and so on, and not people like Hobbes and Bentham, who of course never called themselves legal positivists because the word positivist was not invented until after they died. And I think they were very different. So what do I mean by saying that legal positivists get everything wrong? So the first thing is that I'm a naturalist, and most legal positivists, despite Leiter, about whom I'm going to say a few words in a second, are not. And I've written quite a bit about this. Hart is not a naturalist. Raz is definitely not a naturalist, and those who come after them are quite explicitly not naturalists. So that's one reason, one aspect that I think legal positivists get wrong. Even with respect to Leiter, I think the problem with him is that that may again come as a surprise, not naturalistic enough, because he still allows for conceptual analysis. And for me, the whole conceptual analysis project has been a big mistake. And if you read my paper, you can see that somewhat surprisingly, or perhaps not, Dworkin ends up being quite a bit of an ally on this, definitely on the conceptual analysis part, and I think for quite a bit for the naturalism part, even though his story is more complicated. So I'm going to write in a different paper something about this, but that's part of the reason for me to be interested, and I'm going to say a bit more as we go along to explain why someone who's a naturalist can find Dworkin as an ally in some respects. And the second part, and that's easier to understand, is the fact that legal positivists today turn their backs onto political theory. And that's another kind of unfortunate legacy that I think we got from Hart. And there are all kinds of reasons, some of them kind of history of ideas, reasons for why legal positivism turned its back on Hart, on political theory. Some of them I think are more kind of maybe matters of disciplinary division, where kind of legal philosophy had to establish itself as a separate field, and it sort of established itself by contraposition from political theory. Political theory is normative, legal theory is conceptual. And I think this has been a big mistake. And obviously this paper talks about that. So these are kind of my reasons. So what should come instead? In my view, a wholly naturalized legal philosophy. If you want the slogan, the slogan is conceptual analysis, just say no. And this is not really spoken about in the paper, but like I said, there may be some places where you can see why I'm sympathetic to this. And the second part is the opposite to the division from political theory, which is where I think jurisprudence should connect to political theory. And the key idea to me is legitimacy. And that's, again, central to this paper. And so that's it now. But like I say, so even though I don't speak about naturalism in this paper, I hope that you can see that there's nothing inconsistent with naturalism in the paper, and that Dworkin is actually, especially in his account of morality as I present it at least, quite friendly to naturalism. So that's in terms of background. That's not so much in the paper. Now we get to the heart of the paper. Now, in the paper, I present something I call the basic view, which is this, which are 6 points. I actually am not going to talk about. So I'm going to skip that. They're on the slides in case someone wants to ask about them, so we can kind of go back to this. But I'm going to decide to present it without the basic picture. But just to say, for those who kind of, a reminder for those who looked at the paper, I say, here's 6 points that I think are more or less considered uncontroversial by most legal philosophers, not 100%. So recently, Mark Greenberg kind of is an example of someone who rejects some aspects of the basic picture, but these are generally widely accepted. And because they're so widely accepted, there is an assumption that Dworkin accepted them as well. And so his disagreement with legal positivism is with the rest of legal theory, and especially legal positivism, is confined to point 6 and maybe point 3. And I argue, no, actually, Dworkin accepted point 1, which is in fact something that many legal philosophers think he rejected. They think he did not think that laws of human creation, whereas he definitely did. But but I think he rejected 2 to 6. So that shows that Dworkin is far more radical in his rejection of, or far more different from the sort of mainstream view of legal philosophy than is usually accepted. But now I'm going to kind of start my presentation again, perhaps to bore myself slightly less. I did it slightly differently from the paper itself, but it's fairly consistent and faithful to the paper. So here's a way of starting the paper. So a central question in jurisprudence is many people consider it the basic question, the first question of legal philosophy: what is law? And here are 3 possibilities. So the first possibility, and the one that most legal philosophers take to be the right way to think about this question, is a categorical or conceptual question. There are debates here, and I've written about this elsewhere, about divisions among this, but I'm not going to go into this. The assumption here is that there is a question which is non-sociological, non-political, and independent of what most people may think about the matter, about what law is. And it's a matter of almost, you might say, I'm actually think that that's the only way it can make sense of it, a sort of a priori conceptual analysis or something along those lines. And I mentioned quite a few people who adhere to this view. So John Gardner, Les Green, Scott Shapiro, Andre Marmor, Julie Dixon, and many more. There is an interesting, again, kind of talking about history of ideas. There's now a kind of attempt to add heart to this story, to say he was actually part of this story. I actually don't think so. If you want to trace who actually is responsible for this, in my view, mistake, it's Kelsen via Raz. So Raz, at least in his early writings, is an exponent of this view, and he himself takes it from Kelsen. Early Raz is very different from Hart. And that's one of the senses in which he's very different from Hart. And so that's where we get this view. And like I said, there is now work of sort of interpreting Hart, trying to show that he was part of that story too. Now, I'm not going to say that there isn't a hint there or a sentence here or there that you can't kind of read him this way, but I think it's fairly obvious, at least to me, that wasn't Hart's view. Hart was more in the second story, about which I'm going to say something in a moment. Now, Dworkin says about this project, and I completely agree, this is a failed project. There's no such thing. So Dworkin doesn't spend a lot of time about this, but he says, for this project to make sense, law needs to have something like a DNA, and law doesn't have a DNA. So no DNA, no, this project failed. I think you can say more about this, but a lot more. But ultimately, I agree completely. This is a failed project, in my view. Again, this is not part of my paper. I can talk about this more if you want, but it's not, it's kind of assume this with me. Second project is a sociological project, which is what people think about law. And that's Hart's project. Again, this is controversial, but there's quite a lot of evidence in the concept of law that this is what Hart means when he presents his project. So he himself calls his project descriptive sociology. And he himself says that what I'm going to present to you is the views of educated people. And there's a lot more. Of course, the whole project, the whole use of linguistics is a way of, I would argue, a way of kind of empirical sociology. Very poor empirical sociology in my book, but a kind of empirical, an attempt at empirical sociology. So that's project number two, to which the response is, and again, Dworkin says it very briefly, there's again more to say, but the response is, sure, that's a valid project, but if that's what you want to do it properly, and that's not the proper way to do sociology. So, sitting in your armchair and contemplating about the linguistic distinction between obliged and obligated is not the way to get to general conclusions about what people think about law. Since actually I have a Brazilian audience, I will say that now some people in Brazil, Noel, for example, are at the forefront of actually trying to do this kind of work more properly by investigating it empirically. So I definitely don't think that this is an implausible project, just that Hart and followers did it badly. Now you might say, well, if there's not one or not two, then there's nothing left. Not so, I argue, says Dworkin, not so, I definitely say. There's a way of making sense of this project, a third way of understanding the question of what is law in terms of a political question. I trace it to Augustine, if you want kind of a historical connection, who asked, what is law, what is government without justice? What's the difference between that and a bunch of robbers? And Hart, of course, gives this question a kind of a statement to this question when he distinguishes between, or tries to distinguish between law and the government situation writ large. So this is a familiar way of distinguishing law from non-law. And I want to show you here with some pictures and examples that this is not an implausible way. It's not something that I just made up. So here's a cover story from The Atlantic from a couple of years ago. And it says, America is not a democracy. So, and now, what's the proper way to understand this headline? You might say, oh, that's a conceptual mistake. In the US, there is elections every 4 years, actually more than every 4 years and so on. So how can it be that America is not a democracy? And of course, if you read the article, and that it doesn't matter whether it convinces you or not, the argument essentially is, if you dig beneath the surface, you see that it's not really a democracy. It's a sham. It has the superficial appearance of a democracy. But it's not really a democracy. And getting a bit closer to law, so here's another example. So we talk about show trials. We talk about kangaroo courts. So these are things, a show trial, you may say, something that has the superficial appearance of a trial, but it's not really a trial. A kangaroo court has the superficial appearance of a court, but it's not really a court. And why is that? Well, at least arguably, you can say that it's illegitimate. And what makes it illegitimate? Well, you can tell a story about that. That's at least the kind of thought that I urge you to think about. And that's the kind of thought that I suggest that's what you find in Dworkin. And here's an example of actually speaking about law. So I found this is from an article by Bill Eskridge, 1994. One who has been declared an outlaw literally beyond the Constitution's protection is less likely to ascribe legitimacy to decisions that condemn her. To us, Hardwick and the military exclusion cases are no more legitimate than Dred Scott was for pre-Civil War slaves or Korematsu was for Japanese Americans. These decisions are not law because they deny us our citizenship and because they subject us to violence and so on. So this is, of course, in the context of back then, the criminalization in the United States of same-sex sexual relations. Now, again, you may disagree with that, but I don't think you can say that Eskridge here is making conceptual error. You can't say that what he says you can't understand it. And if you can't understand it, I say that's what you need to understand Dworkin. Okay, so that's it. That's in terms of that. All this is sort of just by way of background for the paper. And now here's the interesting thing. Sense one, the categorical, leads naturally to the idea that to understand law, you need to identify criteria of legality. Why? Because each criteria of legality is what distinguishes law from non-law, and the nature of criteria of legality tells us about the nature of law. Okay, so the criteria of legality change between one legal system and the other, but the criteria themselves have a certain nature. They have certain features that are universal, and that tells you the nature of law, right? That's project one. But if you understand legality in sense three, so legality may relate to legitimacy. You can think of legitimacy in a different way. You don't need to think about it through criteria of legality, but rather through ideas of legitimacy. And how is that? Not through the idea of validity, which has no role in Dworkin's account, but through the idea of content, legal content. And when you think about it in this way, legitimacy effect is relevant, potentially at least, for law comprehensively. What do I mean by this? Legitimacy affects not just the end case, extreme case, which is the illegitimate law is not law. It's questions of legitimacy that are asked at the most general level. What makes law legitimate? Have downstream effect on how we understand the content of law, right? And that's a crucial point. It's a crucial point because it creates a connection between the what is law question in general and what is the law in particular cases. A question that in the story, in the validity story is a mistake, right? That's a mistake that many legal philosophers say Dworkin commits. They say he doesn't understand, he constantly confuses the question what is law with what is the law. Whereas if you understand the project through the lens of legitimacy, it's not a mistake at all. Or at least potentially it's not a mistake, because if you look, you may have a theory of legitimacy where there's downstream effect from the question of what makes law legitimate in the abstract to questions of, for example, statutory interpretation. And then there is a connection between the two questions. And then, so then that's an important point number one. And then you may end up concluding that sometimes there is something that has the superficial appearance of law, but is really completely illegitimate, that it's not law. But that's just the end point of legitimacy affecting content. Okay, so that's the way I propose to say it. Okay, so that's it. And I think this is, if you understand this, you understand quite a bit about Dworkin, at least as I read him. And that's already a very significant way of thinking about law and legal theory that's radically different from what we have so far. And I could almost say I could stop here, and there's a lot to talk about here, but in some respects, now comes the interesting part, because now Dworkin has an account of the relationship between law and morality that makes morality depend on law. And that may sound very surprising, not to say crazy, because I argue that there is a view that's very, very widely accepted among legal philosophers. I call the imitation view. And roughly speaking, the idea is this. I think it's fairly intuitive, so I don't need to explain it too much. Morality is the benchmark. Morality is the blueprint, right? So morality exists. It's a timeless, it's universal, and it's the model against which we compare law to, right? And so to the extent that law does not match universal morality, law is deficient. It needs to be fixed. There is an aspect of where law can kind of go beyond morality. This is the idea of determinatio, right? So law requires that we protect people against harm. So it may require that it will have speed limits on cars. It doesn't tell us exactly where, right? That's the idea of determinatio. But beyond this, the blueprint idea is very, very widely accepted. I think we should reject the imitation view, especially if you're a naturalist. I'm not going to talk about my views here, although, again, in Q&A, you may ask me why or how I think that. But I will say this, and because this is the topic, Dworkin clearly rejects the imitation view. He explicitly and clearly rejects its injustice for hedgehogs, where he adopts the so-called one system view. He explicitly, contrary to some people who say, oh, that's something that appeared only in 2011, explicitly rejects its injustice in robes in 2006. And I put the page numbers in case you want to check on me. And I argue in detail in the paper that already in Taking Rights Seriously, 1977, in fact, an article already published in 1973, he rejects it quite clear. And he proposes an alternative, the constructive model or the common law model. He proposes it in a review essay of A Theory of Justice, which is chapter 6 of Taking Rights Seriously, previously published University of Chicago Law Review, if I'm not mistaken. People who are better Rawls scholars than me say that's a very implausible interpretation of Rawls. Maybe so. That doesn't matter because it's quite clear that that's a view that Dworkin adopts himself. And in this view, morality is not timeless. Morality is not unchanging. Morality is not universal. Morality is a human construct. And in this picture, law is a very central component or element or location where this human endeavor called morality is constructed. Now, this is where interpretation comes in, right? It's not simply the idea that, oh, the sum of people's views about what's right and wrong is morality. The whole point is that this is the raw material, which is available for all of us to interpret and reinterpret. That's how he gets a story about objectivity. That's how he gets a story about the possibility that people could get morality wrong. But it's still the raw material is always human attitudes, human discourse, right? And this is, I really think that this is sort of non-negotiable, not in terms of, if you don't accept this, then I will say this is outside the realm of acceptable interpretation of Dworkin. This is, I think, very, very clear. If you read the relevant pages, 160 to 163 of Taking Rights Seriously, if I want to be specific, and there's more about this in the response to critics, still in Taking Rights Seriously. So that's very, very central. And now, kind of hint, kind of a star footnote or a footnote for my claims about naturalism. So obviously, if you're a naturalist, that's a story that you're going to like quite a bit, because if you're a naturalist, of course, there are many naturalists, but if you're a naturalist, this story is easy to understand. It doesn't require you to assume any kind of weird, queer, to use Mackey's term, properties to morality. It's a human creation. And here, I hope you can see, so I added, just to say that this is not a crazy view or that it's a view that's been sort of taken up. So Philip Kitcher published 2011, if I'm not mistaken, a book called The Ethical Project, a very interesting book, which in some respects is very similar. It argues that morality is a human creation. It's a project that we are all participants in, and it's a thoroughly and explicitly naturalistic story. So, I'm not saying the stories are exactly the same, but I read Dworkin as broadly in the same ballpark as Philip Kitcher in this book. Okay. And now you can see the importance of law, and particularly the common law, because the common law is exactly this endless discourse in which we're trying to find the answers to new questions from within. And I quote, so I mentioned that Dworkin talks about Neurath's boat, and I quote Matthew Hale in the 17th century, in fact, written in the 16th century. No, sorry, published in the 18th century, written in the 17th century, using exactly the same metaphor of the boat that's being reworked at sea. And Dworkin talks about law as a seamless web. Dworkin talks about law working itself pure. These are remarks that have generally been ignored by interpreters because they assume that Dworkin is this hardcore moral realist with morality pre-existing humanity, but he's really not. And all these statements make sense. Now, notice if you read those passages about in the review of Rawls, he doesn't talk there about law. He talks there about morality. This is very important. He says, interestingly, lawyers will be familiar with this model of morality because it's similar to the common law. So Dworkin says, my model for morality is the common law, okay? And it explains a lot of other stuff. So Dworkin says, judges don't make law, but they don't invent it either. They do both and neither, right? So what does it mean? Well, if you understand the story that I say about, in some respects, the raw materials are there. So judges don't invent anything new, it's already there. But they also, so in some respect, they find their answers already there, but they invent something new, right? They do create something new. And Dworkin explicitly calls his interpretation creative. He doesn't, so again, against the view that's so often ascribed to Dworkin, judges just find the law. No, Dworkin explicitly says judges don't just find the law, they create. He's not very warm to natural law theory, the standard understanding. He rejects moral realism. He explicitly adopts the one domain view. All these things make sense if you understand his view of morality in the way that I explain it. And as a bonus, and it's a long footnote in my paper, I say, it also helps explain various other stuff that Dworkin talks about. Dworkin has views on equality, but he, of course, he wrote extensively about this. He basically wrote nothing about global justice. Why is that? Well, because morality is a product of a community. So global justice just doesn't fit in that story until we create a global community. Even more explicitly, Dworkin has a very puzzling interpretation of international law. The purpose of international law, he says, is internal, is domestic, is to create better justification for domestic law. How can this be? Wrote various people who read this posthumously published paper. That just doesn't make sense, they said. Well, it totally makes sense if you think that morality is the product of a particular community. Until, and there is a little comment in the paper about this, we create a global community. Once we create a global community, you could have international law that's understood differently. I don't say this in the paper, but I also think that you can make a lot of sense of this otherwise quite strange paper, Objectivity and Truth, you'd better believe it, if you understand his views on morality in the way that I just described. Okay. Now comes theoretical disagreement. How much have I been speaking for too long?
Perhaps then, can you finish in 5 minutes?
Okay, so you know what?
We're reaching the end of part one.
So, okay, so I won't speak about
this topic. Yeah, good.
I'll skip theoretical disagreements. In some respect, you may say it's actually independent of the paper. But although I think it definitely fits and ties to the idea of legitimacy, I do want to speak very, very briefly about the final part of the paper, this sort of history of ideas. And so was Dworkin where do we place Dworkin? Was he a natural lawyer? Well, not really. If he didn't really, he quite clearly did not see himself as one. Was he a legal positivist? Very clearly not. And some people tried to say that he was, but it's obvious that he wasn't. And not just because what he said, there was very little between him and legal positivism. He's also not just a theoretically ambitious lawyer, as John Gardner at least once called him, by which he meant he had some stuff to say about American constitutional law, but he didn't really deal with the questions of jurisprudence. If I'm correct, he definitely was more than that. But now we can see him as something else, common law theorist. Now, what is common law theory? Well, I propose three that we think we divide the world of legal theories, not based on questions of validity, is morality criteria of legal validity or not, but rather on the basis of theories of authority. What's the account of authority at the basis of law? And if you accept this, then you don't have just two, yes to morality, no to morality. You have multiple options, at least three: will-based theories, reason-based theories, and community-based theories. So the basis of authority on the first one is an act of someone in power, that's Hobbes. In the second story, it's when law matches reason. That's Aquinas, Finis, if you want, in modern times. And you have a very popular view, in fact, community-based, custom-based view, which is Burke, which is Cardozo, and which is Dworkin. Now, there is a very important work on common law theory, first by Brian Simpson and then by Gerald Postema. I think the work has been ignored because people did not exactly know where to fit it in the legal positivism versus natural law story, understood as competing theories of validity. But if you understand the divide that I propose for theories of jurisprudence, then it fits quite naturally and easily. It's just a competing account of law's authority, and which says law's authority comes from its correspondence, broadly speaking, with the values of the community. How exactly you spell this out, there you have lots of options. But Dworkin fits into this. And then in just one word, this is sort of a shout out for a paper that I'm still working on. If you agree with what I said before, then Dworkin was a legal realist, because many legal realists, although definitely not all of them, but definitely some of the most famous ones, Llewellyn, Cardozo, Corbin, Green, Radin, and Jerome Frank, were all common law theorists, because they all accepted that the authority of law comes from community. That's why they were all anti-naturalists. They were all humanistic in orientation. They liked and sometimes even loved the common law, e.g. Carl Llewellyn. And they also thought, contrary to what most people will tell you, that law is generally determinate and guiding. When it's guiding, when it's connected to the values of the community. So that's it. I know there's a ton here, but at least I think we won't be, there will be questions and discussions. So I hope
yes, we look very forward for that. Then I got actually a few messages asking you to conclude. Yeah, but thank you very much. You presumed it very well, and the people who did not have a chance to read will be able to get your main ideas. So there's space for some comment here by Thiago. So I will ask you to go through these comments, Thiago, and then we will open up for questions. Okay. Thiago will speak, then we'll have just a very short reply, and then we will open for questions in blocks of 2 or 3, depending on the number of people who show interest in making questions. Okay, Thiago, go ahead, please.
Okay, first of all, I'd like to thank Thomas for putting this event for all of us. To thank Dan Priel for his paper, which I liked quite a lot and agreed in great measure. And I believe this makes my comments less interesting than they would be if I didn't agree with much of it. But I will read it because it's easier for me to keep track of the arguments. It's a bit long. I'll try to not lose myself in the details and just read it through. And so I'll just begin.
Okay. Can you share the screen with us, Thiago?
I have it on a print version because I've made many corrections and
okay.
and I cut some parts of it.
Okay,
Priel's thought-provoking paper on Dworkin's jurisprudence intends to show his legal theory in a wider context and a more favorable light than its traditional reception by most scholars in the Anglo-American legal tradition. He aims at doing this by rejecting the interpretation of Dworkin as a natural law or as a positivist theorist in the legal theory level and as a moral realist in the metaethical level. The strategy used to accomplish this task is to summarize a set of theses on morality and law and their relations into what he calls a basic picture that he takes to be pervasive, widely accepted, and took for granted as underpinning any serious attempt at engaging in jurisprudential debates. The basic picture takes law to be a human creation, contrasting in this sense with an understanding of morality as timeless, universal, and independent of human action and social practices. Although allowing the acknowledgement of necessary connections between the two normative spheres, these differences imply that law and morality are distinct domains. One of these connections is the role of a regulatory ideal morality plays regarding law. However, since they are distinct normative domains, there must be some set of characteristics that distinguishes them. These criteria of legal validity, albeit sensitive to contingent social factors and varying from a political community to another, exist in every legal system, and the identification of its essential or functional common core is the central task of the philosophy of law. According to Priel, the wide acceptance of the basic picture is also behind the commitment of many legal philosophers to a conceptual approach, understood as descriptive and morally neutral, since this picture takes as central the identification of essential features of law in the form of validity criteria. In this regard, even natural law theorists' inquiries could count as descriptive, since they aim to justifying the thesis according to which a proper description of law would include moral content in validity criteria. Priel believes that Dworkin's legal theory seems inconsistent or nonsense to many legal philosophers precisely because they presuppose that he is trying to theorize about law under these assumptions. Therefore, since Dworkin clearly recognizes strong relations between law and morals, many think he must have been talking all along about morality as a criterion of legal validity, being a natural law theorist. The attribution of this commitment to the basic picture has also had the opposite effect. Dworkin's constant engagement in normative arguments regarding concrete legal questions made it difficult for many to see Dworkin as a legal philosopher. Priel argues that both readings are mistaken. The key to understanding his legal theory, therefore, is to realize he rejects most of the basic picture, retaining only the idea that law is a human creation. Priel locates Dworkin's acknowledgement of commitments incompatible with the basic picture already in his early work. He believes that clarifying Dworkin's metaethical views regarding morality and the origins of its interpretive methodology can help us better understand and appreciate the contributions of law's integrity to jurisprudence and its ongoing relevance in the debates in the field. Beginning with the issue of legal theory methodology, Priel argues that Dworkin's insistence in running together questions of what law is and the question of law's legitimacy, often understood as a philosophical error, is in fact an expected consequence of his rejection of law as consisting of a limited set of discrete normative patterns that can be distinguished from non-law by some fixed set of validity criteria. Priel points to the rejection of a criterial understanding of the concept of law on the basis of their incompatibility with theoretical disagreements, as proof of the fact that Dworkin rejected the basic picture. The first remaining possibility would then be to derive the concept of law from a sociological generalization of what law is taken to be. Although possible and worth pursuing, this would be an empirical investigation into the use of concepts. Even if it can be argued that the descriptive conceptual project of analytical jurisprudence might be better understood this way, the data gathered and its methodological treatment so far appear to be inadequate to provide the grounds for the claims made. The other possibility is to understand the concept of law, along with other related political and legal concepts, as an interpretive concept. The doctrinal concept of law aims precisely at connecting the general question, what is law, to legitimacy and value considerations. Priel's reconstruction of the reasons Dworkin offers in favor of the doctrinal concept of law seems to be as follows. Since law is coercive and makes demands upon us, it matters to know what those demands are and if they are justified. If it can be shown that questions of legitimacy affect how we understand what law requires of us, then considerations of legitimacy may be relevant to answering the question, what is law? There seems to be thus a theoretical path from legitimacy considerations to the concept of law through the impact these considerations have on legal propositions. Priel argues that establishing connections between legitimacy considerations and the distinction between what is law and what only has the appearance of law is not a recent theoretical move. Part of the justification for this connection is the role played by legitimacy considerations in deciding the application of relatively abstract rules to singular situation or cases. As Priel is ready to remark, this does not mean that law must be legitimate or that there is a conceptual contradiction in the idea of unjust law. The conclusion of the argument is more nuanced and more interesting since it does not depend on the notion of validity criteria. And I quote Priel. It suggests that questions of legitimacy potentially affect the content of law in a much more pervasive way. End of quote. To ground this suggestion, Priel suggests that the distinction between what is and what is not law on the basis of consideration of legitimacy can also be found implicit in a plausible reading of Hart and Rass. In Hart's case, he argues that the addition of secondary rules to a regime of non-official primary rules is relevant to law's legitimacy. The reason why having court matters, besides considerations of efficiency, is that it gives people involved in a judicial case the chance to be heard and contribute with their arguments to the decision, increasing the legitimacy of the practice. If one tries to keep legitimacy out of the equation, arguing that having courts makes a difference because systems built like that reflect our intuitions about law, it is possible to argue that the whole enterprise rests upon a normative premise according to which law should look like just what we have. In the case of Rass legal theory, one argument raised in favor of strictly factual determination of law, the Sor thesis, is that people must be capable of finding out what law is and acting on it. However, Priel claims, this claim makes better sense as an argument about law's legitimacy than as a conceptual claim. And I quote, one aspect of making legitimate demands is that those subject to the demands need to know them in advance so they can adjust their behavior, end of quote. The next step in the argument then is showing how political questions regarding legitimacy affect the content of legal norms in a way that answers to the question of what law is. Priel accepts Dworkin's criticism to the positivist view on the matter. The idea that easy cases are decided by applications of pre-existing legal rules, identified by many as accepted factual sources, is based upon contested claims that law in general is made up of rules and that their content can be immediately grasped once they are identified. These claims cannot be understood as facts about linguistic meaning of law on account of Dworkin's treatments of theoretical disagreements. Furthermore, as part of the institutional political structure determining what people have to do, the function of courts in determining the law is entangled with arguments that affect law's legitimacy. What is taken to be required for courts to follow the law depends on arguments of political theory. The point can be summarized as follows, and I quote Priel again. Accepting the relevance of legitimacy to understanding law in general has downstream effects on understanding the content of laws. This explains the connection between the general question, what is law, and the concrete one, what is the law in a particular case. Up to this point, Priel's reconstruction of Dworkin's theoretical commitments strike me as correct. If this is right, Dworkin is neither a positivist nor a natural law theorist. He is also not alienated from the legal philosopher interests because there are reasons for running questions of abstract conceptualization of legal practice together with questions regarding what law demands in concrete cases. When it comes to the defense of a doctrinal concept of law to the detriment of a criterial concept of law, however, Priel points to arguments that do not carry much weight with Dworkin's positivist critics. Dworkin's consideration concerning interpretive concepts and therefore the doctrinal concept of law can be further strengthened if it is possible to show that the use of this type of concepts to understand linguistic practices is not unprecedented. In some ethical and metaethical debates of the end of the past century, it has been argued, for example, by Putnam, that there are concepts whose conditions of assertability require evaluations. These thick ethical concepts, concepts like cruel, gorgeous, equitable, democracy, etc., bear a remarkable resemblance to Dworkin's political and interpretive concepts. In the impossibility of attributing exclusively factual truth conditions for the propositions that contains them. Employing these universals to qualify a particular require factual as well as value conditions. These conditions are entangled in a way that cannot be factored apart without compromising its meaning. Employing these concepts is making value judgments. If this is plausible, there seems to be a partners in crime kind of defense available to Dworkin and Priel. Positivists trying to debunk interpretive concepts, such as the doctrinal concept of law, would have either to argue, despite appearances, there are no thick ethical concepts, or that no technical legal concept is a thick ethical concept, or that legal propositions containing these terms can always be reframed in purely evaluative and purely factual claims. The acceptance of legal concepts as thick ethical concepts can also be used to separate the search for the content of a concept and the idea that in doing so, we are merely describing common criteria for the use of concepts. Conceptual analysis might not have to be understood as an exclusively descriptive and non-evaluative activity. The last part of the argument regarding Dworkin's rejection of the basic picture concerns the relationship between law and morality. Priel argues that the view usually attributed to Dworkin is in fact the opposite of the view the philosopher holds. According to this view, law is socially constructed, changing and contingent, while morality is independent of human actions and beliefs, pre-exists law, and is not affected by it. Since it has objective force, moral imperatives normatively bind not only human action, but human law, and both can comply or not with these requirements. Priel calls this understanding the imitation view and argues that those who take Dworkin to be a realist find it easy enough to attribute the imitation view to him. He, however, attributes Dworkin a completely different metaethical theory, moral constructivism. The kind of constructivism attributed to Dworkin reverses the imitation view and models morality after the constructive practices that produce and apply law, as understood by the common law theory. The quotation Priel offers in support of this reading bears a great resemblance to Dworkin's future description of his interpretive methodology in terms of fit and justification. The constructive model, and I quote, treats institutions of justice not as clues to the existence of independent principles, but rather as stipulated features of a general theory to be constructed, as if a sculptor set himself to carve the animal that best fits a pile of bones he happens to find together, end of quote. As Priel stresses, this understanding of moral practices aims at delivering the conception of justice that best accommodates the community's shared convictions, but it presupposes that the community members hold conflicting moral views that make the constructive procedure necessary in the first place. Understanding Dworkin as a metaethical constructivist dovetails nicely with Dworkin's defense of the objectivity of legal propositions and acceptance of theoretical disagreements on the grounds of law. Priel's argument also attributes to Dworkin the view that since they are constructed, moral rights may vary, and that the conception of objectivity applicable to them is not metaphysically grounded. Priel allows us to see that the similarities between constructive procedures in law and morality are obtained by a modeling that has the direction of fit that leads from morality to previously conceived constructive conceptions of law. Morally and legally right answers are not found nor invented, but constructed in an argumentative activity in which competing answers creatively interpret the same practice. Constructive interpretation aims at determining prospective guidance through retrospective reconstruction of the practice, discerning norms implicit in practices as it progresses. Each new application of the law is then incorporated to the data that constitutes the material of the practice to be passed along and further interpreted. Priel not only sees this method as Dworkin's way of understanding law and morality, but also shows Dworkin's agreement with the extension of the method to understanding society and its practices. The possibility of extending Dworkin's constructivist method to understanding not only law and morality, but social practices in general, finds additional support in the use that some philosophers of language make of an analogous model for understanding the linguistic practices of a community and conceptual determination in general. When defining a kind of rationality involved in conceptual determination called expressive rationality, Robert Brandon claims that there is nothing in the content of a concept besides what has been conferred on the concept by past applications of that concept and other concepts inferentially connected to it. Trying to answer the question of how can any current application of a concept be understood as correct or incorrect according to a content instituted by previous uses, he claims in a phrasing that resembles Dworkin's constructive interpretation that, and I quote, "The authority of past applications, which instituted the conceptual norm, is administered on its behalf by future applications, which include assessment of past ones. It is for later users of a concept to decide whether each earlier application was correct or not, according to the tradition constituted by still earlier uses. In doing so, the future applications exercise a reciprocal authority over past ones." End of quote. The valuing component of Dworkin's constructive interpretation of normative practices also finds an equivalent in Brandon's model of concept determination. And I quote again, Brandon again. "At each stage in this development, it is insofar as one takes the tradition to be rational by a vigorous rewriting of its history that one makes the tradition be and have been rational." End of quote. If it makes any sense to think that conceptual content determination in general can be explained along these lines, it would not be far-fetched to understand the same procedure as involved in the determination of the content of moral and legal concepts. By tracking in text from the beginning of Dworkin's career, arguments that show commitment to a view quite similar to the recent single domain thesis, Priel demonstrates that the idea that morality and law constitute a single integrated normative practice is an expression of his long-held commitment to metaethical constructivism. Since, for Dworkin, there is no morality in the absence of moral practices, and since he also rejects talk of having no legal rights while having moral rights to a decision as a misunderstanding of his thought, Priel finds it possible to conclude that he takes law to be a central element of moral practice, an explicit token of the community engagement in the interpretive practices in order to construct its moral world. I believe that Priel's interpretation of Dworkin as a metaethical constructivist makes the best overall sense of his theoretical commitments. The problem such account must face, however, is Dworkin's explicit disavowal of constructivism and metaethical thought in general in Justice for Hedgehogs. The disavowal of constructivism is mostly based on the idea that a constructive account of morality, and I quote, "cannot be a morally neutral project, because any interpretation of a political tradition must choose among very different conceptions of what that tradition embodies. Without a background moral theory that we take to be true, we can have no idea which idealization to choose." End of quote. These remarks, however, are not a problem for Priel's interpretation, since nothing in the reconstruction of Dworkin's view as a constructivist eliminates the possibility, or even the need, for attributing a point, therefore a value, to moral practices in order to get the constructive interpretation of the ground. The problem of the rejection of the whole theoretical enterprise of metaethics nevertheless remains. One possible solution would be to challenge Dworkin's presupposition that all metaethical theories are Archimedean theories. One could then follow Kevin Thaw in recognizing that, and I quote, "There clearly are metaethical theories with Archimedean ambitions, but much more common are those metaethical theories that are supposed to form a mutually supporting network of theories with their first order ethical or legal theories, end of quote. If Tao is right, it is not the case that every time a metaethical proposition is in tension with normative judgments, the latter should be abandoned. And I quote, often the thing to do would be to make adjustments or modifications in both to mitigate the tension and thereby enhance the credibility of the package as a whole, end of quote. This would mean understanding the relation between metaethical theory and the first order propositions whose normativity it explains in terms of a kind of reflective equilibrium. Although contrary to Dworkin's words, I believe that this understanding would be not only consistent with Priel's interpretation of Dworkin's legal and moral theory, but also coherent with his concerns regarding integration of values and normative beliefs as signs of correction. Since moral constructivism rejects the existence of morality outside of moral discourse, the attribution of constructivism to Dworkin's views on morality would still grant the internal character of moral justification Dworkin treasures. In the last two sections of his paper, Priel deals with the question of situating Dworkin's view in the jurisprudential landscape. Having argued that Dworkin rejects the basic picture and with it the criteria understanding common to positivism and natural law, he sees the philosopher as belonging to the tradition of common law theory. What justifies this attribution is the fact that common law theory grounds law's authority in community instead of locating it on acts of will, as positivism does, or in reason, as natural law does. Priel takes Dworkin's legal theory to undertake common lawyers' commitment to understanding the law as continuous with community standards and its authority as derived from the acceptance by, law as continuous with community standards and understanding its authority as derived from acceptance by the community. In the same way that classical common lawyers grounded law in common reason, understood as a form of reason derived from the wisdom accumulated in practice, Dworkin grounds law on the reconstruction of norms implicit in practice through the method of constructive interpretation oriented by integrity. If Priel is justified, as he seems to be, in attributing to Dworkin a constructivist metaethics that extends the morality, the blurring of boundaries between normative patterns and community's values, it is possible to attribute to his view yet another tenet of common law theory, namely the possibility of reciprocal influence between legal decisions and community values. As a result, the extraction of law's ideals from within the practice, as understood by Dworkin's one domain view, has the consequence of blurring the distinction between law as it is and as it ought to be. Priel believes that highlighting Dworkin's acceptance of common law theory commitments also unpacks his metaphor of law as a seamless web, against the idea that law should be understood as a limited set of normative patterns. Law is understood. 1 minute, I got confused here. I'll start again. Priel believes that highlighting Dworkin's acceptance of common law theory commitments also unpacks his metaphor of law as a seamless web, against the idea that law should be understood as a limited set of normative patterns. Law is understood as the conclusion of deliberations that take the materials made available by tradition and past practice as mere inputs. Normative patterns are understood, therefore, as interpretations. The last step in Priel's project of situating Dworkin is bringing him close to a variant of legal realism. The main difficulty with this argument is that the legal realists are often interpreted as skeptics who take laws indeterminacy to mean that judges manipulate the materials made available by the practice to justify a posteriori the decisions they reach on the basis of private political ideology, class interests, and private conceptions of what would be better for the society. Since this would, if true, make it impossible to reconcile realism with Dworkin's correct answer thesis, Priel concentrates his efforts in distinguishing a realist conception that is not committed to these ideas and has historical ties to common law theory. These so-called traditional realists, authors like Frank and Llewellyn, are then read from the vantage point of their rejection of law as a set of fixed standards and their shared understanding of legal rules as constructed from legal materials. Once the idea that law is a defined set of patterns that, when applicable, provides the solution of cases without the need to resort to much else is rejected, accepting that judges make use of the materials made available by past practice in conjunction with unspoken ideals implicit in tradition seems to be precisely the kind of constructive process Dworkin has in mind. Priel's main point in this section is that this trend of realism understands community's value as giving law its content and predictability, and that we can find the same ideas in Dworkin's conception of law. My final impression is that Priel's interpretation of Dworkin is innovative and does justice to the author's relevance in contemporary jurisprudential debate. I believe that he is correct in pointing to Dworkin's rejection of the basic picture and in reconstructing the commitments actually undertaken as a combination of metaethical constructivism and a kind of common law theory, normative reconstruction of the practice. In doing this, Priel applies Dworkin's idea that interpreting something is trying to make best sense of the object of interpretation to Dworkin's own theory. I expect that this paper will contribute to bring the Priel's paper will contribute to bring new light to future discussions on Dworkin's view and on legal theory in general. Thank you.
Thank you very much for this, Thiago. It's a very enlightening summary and critical take on Priel's paper. Dan, would you like to say something in response to Thiago? I kindly ask you to do it very shortly. I will add a few minutes to the end of the session. Sure. So if you, for those of you who are, yeah, just a passage before. Those of you who want to make questions, just write me in the chat and I will add you to the queue, okay? So then, after you, Dennis will take his question, okay?
Okay, so very briefly, first, this was amazing. Really, this was I couldn't have asked for a better summary. It was better than my presentation. So thank you so much for this. Also, interesting links, some of which I don't know. For example, the connection with Brandem, I thought, which I didn't know, very, very interesting and enlightening. So thank you so much for this. Very few comments. So one more thing, so just to give you a sense of the way the paper changed. So the version that I sent to Thiago was included the example of RAS, and then I dropped it. So if you kind of said, where is the RAS example about guidance? It's because I dropped this just to, so that's, now, really a couple of comments, just two. One about, so if I understood, you mentioned the idea of thick concepts, and you'd say, legal positivists will try to resist my argument by saying there are no thick concepts or no thick concepts in law. I don't think that will be enough, because I think theoretical disagreements in law. So I'll give you an example. Now that if you follow US news, is you read about it on a daily basis. Originalism, yes or no? So the judge who's now has been nominated to the Supreme Court is an originalist, and suddenly people are kind of debating originalism, yes or no. And so the question is, so originalism versus non-originalism can exist even if there's not a single thick concept in the law, because the whole point is that you may want to understand a certain seemingly clear passage in a statute one way if you're an originalist, and another way if you're not, and that can exist even with no thick concept. So I don't think it's enough for legal positivists to say the law doesn't have thick concepts, or that the thick concepts the explanation of thick concepts is not the one, that follows, let's say, Bernard Williams and so on. So that's a small point. The second small point, so I want to say, so some of you may still want to resist the idea that Dworkin was a common law theorist, or even worse, that he was a legal realist. So I just want to say one tiny point about this, which I say in the paper, so I'm repeating here what I say in the paper. Just like in the context of natural law theory or legal positivism, or in the domain of morality, moral realism, or moral constructivism, each of these labels capture many views, and they have often quite significant differences among them. In fact, quite often you see legal positivists arguing more among themselves than with natural lawyers. It's kind of, you know, natural lawyers, oh, they don't get it. There's no point in arguing with them, right? They're kind of antediluvians, so there's no point in talking to them, but I can talk with another legal positivist. My point is, by me saying, look, Dworkin is very similar in some respects to Carl Llewellyn, or even, believe it or not, Jerome Frank, I'm not saying they will necessarily agree on everything, just like, you know, legal positivists don't agree on everything. I only say there is a very important sense that they will agree on something, which is the basis of law's authority. Beyond this, I want to say, and this is really not part of this paper, but it's just part of my general gripe about people not reading the legal realists, or just reading them third hand or fourth hand. And so reading them as some kind of, you know, Derrida of the 1930s or something like this. So let me just remind you that two things about Carl Llewellyn. He spent over a decade working on the UCC, Uniform Commercial Code, which is not something that you do if you think that law cannot guide individuals and it's just a complete waste of time, and judges do whatever they want and so on. And he actually wrote stuff about this, why he was engaged in this project. And he says, because I want to help judges. You don't say this and you don't do this if you don't think that law is something that can give useful guidance to judges. And the other thing, his biggest book is one that's called The Common Law Tradition, in which extols and celebrates the common law. So just like Dworkin has been read as kind of crazier, weirder version of himself, the legal realists, and it's largely thanks to the CLS people, have been read as crazier, weirder people than they were. So if you do read both of them, you see that they're actually not very different. And the same goes for the classical common law theorists. That doesn't mean that Dworkin did not have something new to say or something different from the ones who came before him. Obviously, otherwise he wouldn't be interesting. So that's it. But none of this is really, I think, in disagreement with you, Thiago. I really thought your comments were exceptional. I really thought they were extremely enlightening. So thanks.
Thank you very much, Dan. So I invite now Dennis to make his question. Thank you. Just another issue. Those of you who want to make questions, let me know in the chat. I will leave 1 hour for discussion, so we can have a few minutes more, okay? So Dennis, please.
Thanks. Well, Dan, thanks for the paper. To call it rich is an understatement. There's so much going on here. I want to just ask a question, but they might actually be more suggestions. It's about your discussion of theoretical disagreements that starts at the bottom of 31. And my comment is, you don't explicate this in the way that Dworkin does, and I'm curious as to why you would do that. The first paragraph, your first paragraph on this topic, mentions statutory interpretation, originalism, considerations judges should be permitted to take into account. Now, none of those are examples from Dworkin, right? Dworkin motivates his discussion with the distinction between empirical and theoretical disagreement. Now, you don't even mention that. And that's kind of strange. I mean, if you're going to explicate somebody's argument, I think you should do it in the terms in which he makes it. This connects to my second point, which is there are three key concepts in the discussion of theoretical disagreement: propositions of law, truth, and grounds of law. You don't mention any of those. So when I read the section, it's like, well, come on, like why would you do that? Why wouldn't you at least just you know, present the argument as Dworkin does, and then do everything you want to, you know, lighter and all the rest. But I mean, this is just basic stuff that I don't understand why you would leave it out.
Okay, good question. So, in a way, I'll answer them together. So I actually do make a brief comment on my generally avoiding Dworkin's terminology in the beginning of the paper. And I say there that the reason is because I actually found often his commentary, his terminology unhelpful. With respect to grounds of law, that's an interesting, so someone else mentioned this to me, and so maybe I do have to mention at least that. So there is at least one thing that is there, and I've worked on this paper so much, and I can't remember if it's in the version that you saw or it's when it introduced afterwards, but it's now, I think there, that I do say that some readers of Dworkin think, Leiter is an example, because he explicitly says so, think that grounds of law in Dworkin is just his term for criteria of validity. So Leiter says criteria of validity or grounds of law, which they just take this to be synonymous. And that's, of course, in my view, a way of pushing Dworkin into what I call the basic picture. So at the very least, maybe it's fair to say to me, you should explain what Dworkin talks about when he says grounds of law, so that you clarify that he doesn't mean by this criteria of validity, because he doesn't, at least that's my reading. So you may say, well, so what does he mean? So what does he mean? It's something like this, as I understand it. So in Dworkin's picture, there's what I call legal materials. There's stuff, there's past cases. And now the question is, but there's also there's other stuff as well, right? It's not just legal materials. We need to not just the sum total of past cases that make up the law. In fact, past cases are not, strictly speaking, the law. It's the principles that you derive through interpretations from past cases, which is the law, and maybe also the decisions that you derive from them. So the grounds of law, I think, are, for Dworkin, are the principles that you derive from past cases. This is not validity at all. So it's important, so I think it's fair to say to me that at the very least, I need to explain this. A, criteria of validity is not the same thing as grounds of law. Two, it's what roughly he means. So that's one. You say, I don't mention the distinction between empirical and theoretical disagreement. I actually think I do. I don't use the term, but I give the example of a book. Is a coloring book a book? And so that's the example that I give, which is kind of similar to the example that Dworkin talks about, for example, when he says, is a bank the edge of a river, or a bank a financial institution? Or actually example more like book, he says, is a very thin pamphlet, is it a book or not, right? And here, that's not a theoretical disagreement, that's an empirical disagreement in Dworkin's distinction. So I do mention this, and I do say that these are not the kind of disagreements that lawyers kind of deeply engage in. And so I don't use the term empirical disagreement. I agree that's true, but I do give an example of one. Now, you also say my examples of theoretical disagreements are not the ones that Dworkin would give. So I think there's something to that. And this is where you might say I'm making a better, presenting Dworkin in a better light, or at least in my view. So I think, in fact, I wrote this in one of my very first papers. I said, where do you, if you're a positivist, where do you put the debate between originalists and non-originalists? And I was sort of still more of trying to help legal positivism, and I put this in the rule of recognition. And so, but I concluded that it's an answer that comes with a great price. I think that this is the best way of understanding theoretical disagreements because of certain interesting features that they have. So for example, the debate about originalism versus non-originalism, or of the 50,000 versions of originalism that are out there, which is the right one. So one of the interesting features that it has, which makes it theoretical, I think that makes it appropriate to use the term theoretical to it, is that it's pervasive, right? You can raise the question of originalism or not to any legal question, as opposed to the local disagreement on the question of whether a coloring book is a book. And so I think, so I think that's where now I'll put it another way, or in additional way. So Dworkin didn't actually engage in debates with originalists and rejected originalism. He of course said, I'm faithful to the Constitution, whereas you originalists are not, right? That was his response to people like Robert Bork. And his sort of answer to them was, my non-originalist way is more faithful to the Constitution than your way. And why is that? Because my account is the one that better fits what I call legitimacy. It's the one that fits the story of fit and justification, as opposed to your originalist story. And so I think that's a clear example of theoretical disagreement. And I would say one more thing. So when Dworkin presents the three approaches before he gets, so he starts with conventionalism, pragmatism, and then law as integrity. So these are three interpretive theories, right? So now, if you look at conventionalism, it's sort of like textualism, or sort of like, so not about the Constitution, but statutory interpretation. It just says, I'm just going to follow the past. Whereas pragmatism, he gives the example actually of law and economics. I don't care about the past. The past is a sunk cost. I'm only looking at the future. Whereas he comes and says, well, integrity is a kind of a mix of both, right? And of course, Dworkin sees this debate between these three interpretive theories as a theoretical disagreement. This, I think, is uncontestable. And so if you agree with me that conventionalism is his sort of name for something like faith to the past as it's been declared in past decisions, then I think that it is a kind of equivalent of originalism, or at least applied to statutes. So I think that A, I'm not going beyond Dworkin, and B, if I am, I would say that that's a way of putting Dworkin in a better light. So that's my why I focus on that.
Thanks, Dan. Let me try to see, would it be okay if we take two questions now, so we could give more space to the audience to make their own questions? I think it would be nice to them. Okay, so we got Sergei Kazatskin. I don't know if I pronounce your name correct. And then Sofia Koval. You two make the questions, then we give the word to Dan. Okay, hello. Sergei, you're up.
Hello, can you hear me? Wait a second.
Yes, please.
Can you now hear me?
Yes, perfectly. Yeah.
You're heard.
Thanks. Dear Dan, could you clarify for me? Maybe I missed something. Why is it? What is your criteria by saying that the Dworkin, you cannot say Dworkin is a natural law or kind of natural law theorist, and what is your criteria for given it to the common law tradition. For me, common law, you were talking about that, but let me say it more, be more concrete. For me, there is a thesis that you cannot, so the thesis concerning law and morality, separability thesis. So Dworkin actually says there is no correct separability thesis. And for me, this is the thesis, or this is the position, natural law position. It's not the classical natural law position, but it's still a natural law position because the debate goes around this. And first thing, and the second thing, why don't you think that we could mark a common law theorists? Why can we make them belonging to some more general theoretical positions like positivist or realist or something like that? Thank you.
Sophia, please. Yeah.
Thank you. Actually, I have a lot of questions, and I think that I should choose only one. Yes, and the most essential question is, of course, I think that connection between Dworkin influence and current debates about subject matter of analytical legal philosophy and legal philosophy in general. As I understand, Dworkin is the first star that subject matter, because he goes through, away from the boundaries of analytical conceptual philosophy. And I'm trying to understand, was Dworkin first philosopher who went through these boundaries and began this dispute about subject matter? Thank you.
Thank you. Dan, it's with you now.
Sorry,
you're muted. Yeah.
Yeah. Okay. So so first your question. So look, there are a million ways of distinguishing or defining natural law theory. There's a quote I once used in a paper by Peter Gay, who said, natural law theory is like the delta of a river that has so many sub-rivers and currents, and they're all kind of going mixed together. So obviously you can define natural law theory in certain ways, in which Dworkin will come up on the natural law side. In fact, Dworkin has one essay called Natural Law Revisited, and he puts the natural in quotes. You can look it up. And he says there, he gives the following definition to natural law. I'm saying this from memory. If we defined natural law, he says that, suppose we define natural law as the view that what law is depends on what it's ought to be, to some extent. If that's how we defined natural law, what's wrong with that? And then he goes on, and the rest of the article is essentially an attempt to show that there is a connection between law, what law is, and what law ought to be. So if you define natural law in this way, that Dworkin defined in that single article, then you could say here, yeah, Dworkin is a natural lawyer. But at least in current discussions, natural law theory is typically understood as the following claim, that morality is one of the criteria of legal validity. In that sense, Dworkin is not a natural law theorist, because he in fact says, he rejects this. I quote in the paper, and he says, some people think that something, if it's too immoral, it can be law. And he says that's a strange view. So he does not accept this standard understanding of natural law theory. You may say natural law theory is the view that there is some kind of connection between law and morality. In that sense, yeah, sure, Dworkin is a natural law theorist, but in that case, John Gardner is also, and Joseph Franz is also, everyone is there's some kind of connection between law and morality. Everyone seems to think that exists. So it all depends on the definition. Now, I propose, because I have come to the conclusion that the idea of validity is a very unhelpful one, to think of natural law about to divide the world of legal theories on the basis of the idea of authority. And on this basis, I say that we have at least three families of views: will, reason, and custom, or community. And on this understanding, the Dworkin, in my view, fits most the latter, the community-based, and that makes him. Now, if you call the second one, the reason-based natural law theory, then Dworkin is not a natural law theory by my definition. So I'm not here to kind of adjudicate on labels. And if you think that it's useful to think about natural law theory in terms of separability, and then sure, he's a natural lawyer. That's fine. But I just one thing that I think it matters here is that actually natural lawyers don't think about, I mean, again, there are many, so some may, but many natural lawyers don't think about their theory in this way. So I don't think that John Finn is properly understood, thinks about natural law in terms of legal validity. He thinks about natural law in a very different way. And I think the second edition and the comments in the second edition to his book make it clear that he kind of wants to distance himself from the whole project of legal validity. Maybe that's how I'm reading him, but go back to the classical exponent of natural law theory, Aquinas. They don't talk about legal validity. So I don't think that's a helpful way of thinking about this view. So then you asked a second question, which I forget now. Oh yeah, why
yes.
Yeah. No, why do I try to associate Dworkin with a kind of common law theory and not something more serious like legal realism? So, well, I actually think that common law theory is really serious. I think that the work of Postema and Brian Simpson has been very neglected and misunderstood because the significance of their work has not been fully appreciated. I really think that common law theory is out there, just an equal level member, if you want. Legal positivism, natural law, common law theory, it's not less important. In my view, it really is just as important as the other two. So when I'm kind of putting Dworkin in that camp, I'm putting him in a very respectable group. So that's my answer. Okay, Sophia, your question. So I should say you got cut out a little bit, so I hope I got the whole thing. So if I understood you, you say, is Dworkin an analytic philosopher or a philosopher, or is he can you repeat the question briefly?
As I understand, I can, have any information about Anglophone philosophy, legal philosophy from articles. And I found a lot of articles about problem of subject matter and distinction between jurisprudence and analytical legal philosophy and legal philosophy at all. So as I understand, maybe I am wrong, that Ronald Dworkin was one of the first person that reject this basic picture and began this wave of the problem of identification of legal philosophy.
Okay.
So maybe there is a
no, that's great. Okay, so I agree with you. So I will say this. So the term analytic legal philosophy can mean at least two things. One is a certain orientation towards, the work that's done in philosophy departments. by which Dworkin is, I think, an analytic legal philosopher. But there is a sense in which people might think about legal philosophy, analytical legal philosophy is concerned with analysis of concepts. In which case, Dworkin is not an analytic legal philosopher. But then, in that case, many philosophers are not analytic philosophers. I think Rawls was not concerned with conceptual analysis of the concept of justice. He was offering a normative theory of justice. Just to give one example. So I think that now you're right that some people kind of want to distinguish legal philosophy from jurisprudence more generally. And so some people might say, oh, Dworkin was doing jurisprudence, but not legal philosophy or something like this. I don't know. I tried in this paper to say that he was engaged with, concerned with, and challenging, radically challenging many of the assumptions of analytic legal philosophers. And so in this respect, he was definitely one of them. He was just offering a very, very different answer because, and this I think also relates to what you said, many people in the business of analytic legal philosophy think that it's a primary question of legal philosophy to identify the boundaries of law. Right, that's what Leiter calls the demarcation question. That's what I call in a paper the boundaries of law question. And so to the extent that Dworkin does not engage in that, they think he's not a legal philosopher. But I think that he correctly challenged this enterprise. Oh, that allows me to connect to another point to Thiago's first comment. So the connection between Dworkin and Brandom is valuable and important because of the pragmatist connection that I hope to explore in the future work. So I think the connections between Dworkin and Quine and possibly Dworkin and Putnam are interesting and underexplored. And so your comments on Brandom, I think, are on point. But Quine is important for dismissing the whole project of analytic philosophy understood as boundaries. And you know, Quine is one of the leading legal philosophers of the 20th century by all accounts. Again, I see him as one of the very first to challenge the project of boundaries. That's why I kind of find Leiter's hatred for Dworkin a bit strange, because Leiter should have said, if you look, my very last sentence is sort of directed at Leiter. It's Dworkin was the first, or perhaps the second, because I think Lon Fuller was there too, and possibly before Dworkin, who challenged the whole boundaries project. The whole idea of trying to find an analytical answer to what law is. And so in this respect, I really think that Dworkin and Fuller, both of whom Leiter hates, are actually much more of allies to his views than he realizes. He should like them for all their issues and whatever, and hate on Dworkin and on Hart and Raz. I'm a bit puzzled here. So yeah. So I'm sorry I kind of drifted off here to something, but I hope that helps answer your question. But yeah.
Then I would have a few questions, if it's all right for me to ask. Yeah. Let me begin by telling you a story about the reception of Dworkin in Brazil. Sure. Brazil has not a very strong analytical tradition. So Dworkin was never read in Brazil in the way that you presented in your paper. I can give you 4 ways of reading work, and all of them, you will find it much more plausible than the Anglo-American way. Mm-hmm. The first way was the way it was read by Lane Streck and other guys who interpreted Dworkin in the light of Gadamer and Heidegger. So he was following this hermeneutic, German hermeneutic idealism and this tradition. Yeah. Okay. The second reading was by the Habermasians, the people from Minas Gerais, Marcelo Cattonio and Menelik. These guys just focused on the debate between Dworkin and Habermas, and they interpreted working as more like a proceduralist, but presupposing an account of communicative rationality. Mm-hmm. The third reading was by the people in São Paulo, Ronaldo Macedo, who read working as a Wittgensteinian and said that he was
as a what?
As a follower of Wittgenstein, and the philosophical investigations, and a linguistic pragmatist. The fourth way was by Thiago Decat, who wrote your comments. He read Dworkin as a pragmatist in the tradition of Robert Brandon. And these readings strike me as all very, very plausible. I can find some of the versions of their works, very shorter versions. They wrote books in English, but shorter works books in Portuguese, but shorter works in English. And I can send you all. And I can tell you that all of these readings are much more plausible, and you would find reason to say that they were not stained by the semantic sting, to put it in a Dworkinian jargon. I thought you would like to know that. Another thing is that although Dworkin was much better received here in theory, there were some Dworkinian judges who began to think they are Hercules. There's a guy, Luis Roberto Barroso, for instance, a very famous Brazilian judge. He wrote a piece in the American Journal of Comparative Law that you can find. I replied to that piece in an article that's going to be published. I don't know when, because the American Journal of Comparative Law takes ages to publish whenever it's accepted. They just warned me that it will take several months for them to send me the proofs, but I can send you the draft in which I say that, look, these guys saying that we can accept Dworkin's aesthetic hypothesis, but we can think about law as abstract, as unconnected with social practices, as something that you do without the local priority, as something that you do when you appeal to abstract concepts that are not interpreted inferentially. So this is another curious fact about working in Brazil. So he was well interpreted by scholars, but the practitioners made a mess of it and used Dworkin to do whatever they want with the Constitution, which is very sad. The other point is that I will not speak about them in the order you presented in the paper, but the first point is about interpretation. I missed an account of interpretation in your paper. The main point of Dworkin is to develop a theory of interpretation, and a theory of interpretation is, and I think that this is where Brandon comes in, and that's why I think that Thiago is one of the best interpreters of Dworkin I have ever read, because interpretation for Dworkin is a matter of attitude and responsibility. So to interpret is to undertake commitments, and when you undertake these commitments, you become responsible for the reading of the law that you're making. Okay. So, and that's the right way to read Dworkin, and I think that you should explore more that in your paper, because I think it is something more sophisticated than constructivism. It's more robust. It's more analytically sophisticated. It requires endorsements, commitments, acknowledgements, and public undertakings and processes. And I think that this is another point that, and I think that perhaps you should speak a little more about Protestant interpretation. You mention it in the paper, but there is something in this, the idea that you can have law without having hierarchies. You can have law without anyone's having authority. So it's like authority is pulverized, is spread among many different people who interpret and make judgments and make laws, but it's a kind of diffused authority. So only, and I think that Jerry Postuma makes a very similar claim. If you read the introduction of the book that we are editing on Postuma, and you are one of the authors, you will see that you can have authority without hierarchy. That's the point that we make. And I think that this is one of the theses of Dworkin. And I think that when you look at interpretation, and especially at Protestant interpretation, and you can make a very interesting point to complement what you said about legitimacy, is that I think that Dworkin emphasizes citizens rather than judges. People say Dworkin writes about judges, but I think that Hart is the one who does that. Positivists are concerned with judges and officials and enactments and commands and this kind of stuff. Dworkin is concerned about citizens. His theory is a theory about self-government, about the attitude citizens undertake towards the law. So there's an ingredient of almost naturalism. Perhaps it should be almost philosophical anarchism. Because you can have law without have someone to say what the law is. So there's not this content independent sayings and the kind of and the way that Andre Marmor defines normativity. It is the law because I said so. No, this is bullshit for work. And I think that this is what makes it more plausible. So I think that when you consider legitimacy again, besides the idea of having law without having hierarchies, is having law, but under a no-neutral moral theory. If you want to call that metaphysics, fine, but or not metaphysics, or metaethics, sorry. If you want to call that metaethics, but it would be in the way that Thiago defined when he quoted Kevin Todd, a non-neutral metaethics. But you must emphasize a liberal. So if you look at chapter 6 of Laws and Power again, he spent pages and pages saying that that's what liberal equality requires. You have to have equal concern. Everyone's life matters the same. So he is a liberal. He's strongly committed to liberalism, and that makes a huge difference in the description of the content of the law that he makes, and it makes a huge difference in the attitudes towards the law that he considers adequate or appropriate. And I think that that's another point. Okay. Can I go on? I would still have other points. I don't know if you're remembering them all, but so you react and then I continue. Okay, go ahead.
So let's see if I remember. So okay, first, so yeah, the readings that you mentioned are possible. I mean, I don't know if it's in this paper, but Dworkin has a very long endnote, which I cite somewhere, in a different paper, about Gadamer in Law's Empire. Yeah. And not just Gadamer, Dilthey, all the famous writers of the interpretive hermeneutic tradition. He also mentions Habermas in that, so page 420 of Law's Empire is there. So it's not without some basis, if you want, it's there. Wittgenstein, well, Wittgenstein, you can do with him whatever you want, really. There's a line that I once saw, which I even used once. Someone said, advancing an argument and citing Wittgenstein as authority is like getting a reference letter from your mom, because every view you can imagine has been attributed to Dworkin, to Wittgenstein. So of course there are aspects of his view that you could attribute to him. I don't know. It's hard to tell without more. The fourth one you mentioned, Brandon. Yeah, I think that's interesting and promising. because Dworkin is a pragmatist in some sense. You know, the paper I'm writing at some point for your next volume, it's about the connection between Dworkin and Quine, and from Quine to get to Brandom is not impossible. So yeah, I definitely see that. Now, so that's on the first. Judges who think that Dworkin just gives them permission to do whatever they want. Well, so that's interesting, and that's actually is jurisprudentially significant, I think. Not just specifically about this. So, you know, in the 50s, there were judges, who relied on Kelsen's view in the case of kind of revolutions, and their writings about this. And apparently some of these people, including Kelsen, said, oh, you misunderstood me. But once ideas are out there, the way that people can do with them whatever they want is interesting. But here's the significant implication of this. It suggests that people who think that legal theory is completely independent of legal practice are mistaken, because legal practitioners read the legal theorists and may come to incorporate, sometimes by mistake, the ideas of the legal theorists. So you may nowadays find legal judges who may think about the rule of recognition. Even though when Hart invented the term, no judge had ever used the term rule of recognition, right? And that actually shows us, and I think that's significant and something that many, many legal philosophers don't appreciate, that legal theory is not simply a description of the practice, because it can change the practice. Okay, next, you said self-government. Okay, so here, I have to share my screen again, because I want to show you something, all of you. So I will share, I think that's the right, yes. Okay, so just for 1 sec. So here's a table of contents of one of the earlier drafts of the paper. And if you look at section 4B, it talked about democratic self-government. So it was there. And it's no longer there, not because I no longer think that, but because the paper has grown too long.
Dan, can I make you a suggestion on this matter?
Sure.
If you look carefully at what Dworkin says about international law,
yeah,
I think that you can add this discussion.
Okay.
I actually I wrote a paper about working in international law in 2017 for the Canadian Journal of Law and Jurisprudence, and I make this point. There is this connection between Dworkin's account of ethics and morality and his justification for aid and harm and personal morality.
Good. Okay, so look it up. Okay, thanks. I will say this. So look, the paper is already something like 35,000 words or 34, so it's very, very long, even by the standards of US law reviews. And so, I mean, maybe what I should now do is just add a little bit more and just go for a book, in which case I can add, but if I don't, then I'm kind of at the limit of where I can add stuff. So that also, I should say, that also touches on the issue of interpretation. So in part, even though look, this is not an attempt to say everything one can say about Dworkin. Some stuff had to be left out. And sometimes for the very kind of anti-theoretical view of this is too long already, but you're right. But I want to say this, so again, I don't know which version you read. I think you read not the version that's now in SSRN. In the version of SSRN, I did add more stuff on self-government, not as a separate section, but in my discussion on common law theory, I said, common law theory is associated with English legal theory, and it's often considered conservative because it's sort of associated with, incremental change, very kind of unrevolutionary. And you might say, how can Dworkin be associated with that? And I say, because Dworkin gives this approach a democratic twist. And that's where I speak, maybe not enough for your liking, but I definitely say more about the sense, more about the Protestant aspect, this idea that for Dworkin, everyone should participate. Everyone is part of the game of determining what the law is. And I even quote now in the latest version, his statement. He says, in Freedom's Law, he says, after the Supreme Court hands out a decision, a debate starts among people, including at the dinner tables, about the meaning of the Constitution, which is, of course, very exactly in line with what you're saying. Everyone participates. And just to show how unusual this reading is, I actually cite a British judge who responds to this. And he says, Dworkin can have his debates at the dinner table. I don't want these debates at the dinner table. So I show here's an American version of common law theory, which is the more democratic, participatory Protestant, if you want, versus a more English version of the common law theory, which is more, it's only the judges who are involved in this in this debate. And that's, again, an example of what I said, that within common law theory, you can have different versions of it. For example, because like, what did I say? I said the core of common law theory is the idea of community, right? That the authority comes from the community. Who is the community? You could say the community is just the judges or just the lawyers. That's a more, if you want, I mean, it's very crude, a more English understanding of common law theory, which is much more elitist. Or you could say, no, the idea, the community, the relevant community is all of society. And that's a much more Dworkinian, much more, if you want, American version of much more self-government idea of common law theory. So it is something that in the latest version is there, maybe not enough, but that's where, as I said, there's limits of space. There is a different paper, I should say, in which is not online, not on SSRN, and nowhere, just on my computer, where I talk more about Dworkin on interpretation and fit and justification and all that. There I actually end up not agreeing with him that much, I have to say, but I acknowledge that there is much more to say about Dworkin than I say here, but you can't say everything in one paper, or at least I failed. But I'll try to add a bit, but really the paper is very long, and even American law reviews that accept longer papers, they don't like papers that are over 35,000 words, and this is there. So I know it sounds stupid to respond to a serious question by saying, I'm out of words, but to some extent that's what it is.
Yeah, I know. I think I mentioned to you that I would suggest you to divide the paper in two, but yeah. you responded, and I was satisfied with your response. I did not like your preface. I think it's a way to prove that you're not you're not a Dworkinian, and I think it's a kind of trying to be member of the club of people who hate working, and I think you're better than that. But there's another issue.
I don't think that after reading, if they ever read this paper, Leiter or Les Green or many others will think of me as a welcome member of their club, because I'm kind of criticizing the reviews quite a bit. So I don't think it's that. I mean, maybe I will cut the preface and then I could add a few more words.
If you take off the preface, I can welcome you in the club, in the Dworkinians club. Okay, so you are very welcome to join.
Okay.
Just one point before I give the word to the last two questions. I have only two questions more. One by Danielle and the other by Sophia. So the point about realism is the one that I'm still puzzled. It's very hard to accept, even though you said some very interesting things. But there are two aspects that I would hesitate. The first is that I'm not sure if Dworkin's theory is as much a predictive theory as you suggest. Okay. And the second point is that many people associate legal realism with instrumentalism and consequentialism. And Dworkin is against all of this.
Okay.
So perhaps you have, either you explain why am I wrong, or don't make the claim, because the discussion was too short for such an important submission.
Okay.
That's what I would have to say to you.
So here, and my first response is look at my other paper, but the paper is not written. So I have a similarly long paper in the works. I can share my screen again to show that I'm not making this up, where I distinguish at length between traditional legal realists and scientific legal realists. My point in that paper is to say these two camps are not slightly different. They're not kind of shades of, they're on many, many issues, almost opposite to each other. So I'll give you examples. Naturalism, the scientific ones, pro-naturalism. The traditional ones, against naturalism. Common law, traditional ones, pro-common law. Scientific, against the common law. Law is a science. But scientific, of course, yes. Traditionalists hate the idea of saying law is a science. And I could go on. And consequentialism is another example. The scientific legal realists explicitly say, many of them, if you read Bentham, he basically said everything that we said 200 years ago. That's what they say. That's what Felix Cohen says. That's what Edward Robinson says. That's what others, at least one or two others. They explicitly see themselves as followers of Bentham. And so, yes, they're consequentialists. They're utilitarian. The traditionalists don't like Bentham. They don't mention Bentham, and they don't follow Bentham. And they're not, and so that's, you know, maybe I have to fully convince you, I have to finish and you know, publish or at least put on SSR that other paper so that you will understand just how different, at least on my understanding, are the traditionalists and the scientific ones. So and then you can see that that it's actually not difficult to see Dworkin as a traditional legal realist. You also said something about prediction. So that's true, but I don't think that the prediction theory is very significant to legal realism. Definitely not the traditional ones. So they talk about this. I don't want to say they don't, but it's, if you read beyond, you know, the 2 or 3 articles about legal realism that people do, you see that prediction theory is a very small aspect of legal realist writing. So and then you can say, you know, they focused on prediction, and Dworkin did not. So here's one difference between them. It's not, in my view, I really don't think that prediction theory is a very central aspect of traditional legal realism. And so, yeah, I'll just give you just one example of the hatred of traditional legal realists to consequentialism and law and science. So Llewellyn, his last 10 or 15 years of his career, he spent at the University of Chicago. And in the last decade, the 1950s, this is where law and economics starts to appear at the University of Chicago. Aaron Director and Ronald Coase and others start talking about this. Now, if Llewellyn had been the scientist, naturalist, consequentialist that you think he is if you read Leiter, you'd say he would welcome this. But he did not. There are, in fact, I can direct you to references to this, that he disapproved of law and economics, the early stage of it. He said he disapproved of the idea of using economics. He disapproved of the idea that, you know, and by the way, why? One reason is because he was a traditionalist that thought that law schools should teach lawyers or students to become legal practitioners. And he thought all this economic stuff does not help people become practitioners. So, so that's just one example, and I could give you 10 more of traditionalists not at all matching the story of, you know, naturalism that Brian Leiter, for example, tells you about. So.
Thank you very much. Let's take the two questions and then finish, okay? So Danielle and then Sophia, and then you answer then, okay?
Sure.
Hello, can you listen to me?
Sure, yeah.
Okay, thank you very much for your presentation. That was really, really intriguing. And my question, I'll try to be as brief as I can, given that, at least for me, it's like way past midnight. So I'll try to be as brief as I can. So I was wondering, when you claim that Dworkin, in a sense, is both a friend or an ally to naturalism and someone that has legitimacy in his views, something that is he's targeting at that, especially if you look at the general concept of law he articulates in chapter 3 in Law's Empire, around which he constructs the conceptions of law in chapters 4, 5, and 6. The concept that he uses in chapter 3 is all about the justification of the power of the state, the justification of coercion. Exactly. So he puts legitimacy right at the front of the discussion in jurisprudence. My question is, if we also see Dworkin as someone friendly or open to naturalism, or more open to social practices and forms of life in general, my question is, if at the end of the day, Dworkin can really have it all. Let me explain a little bit on that. So, is part of our social practices, political practices, or current forms of life in general sense, that we are shot to pervasive conflict and pervasive uncertainty about morality, the kind of objectivity that for instance, you could have in an extremely homogeneous community is not available to us anymore. So in a sense, we have lost ethical knowledge. That was Bernard Williams' point in Ethics and Limits of Philosophy. We have lost the possibility to have ethical knowledge. And if you don't have that, then insofar as you are committed to naturalism, Dworkin is committed to naturalism, he has no way to hold a view on objectivity, given that you have lost ethical knowledge. And if you have lost ethical knowledge and you can't make a claim to objectivity anymore, then the concept, the general concept he was using in Law's Empire to articulate his whole view about justification of coercion, that concept will not be able to do what it was supposed to do, because you will not be able to justify coercion once you don't have ethical knowledge anymore. So my question here is the following thing. Given that, is it possible for Dworkin to actually have it all? He either sticks to legitimacy and becomes a full-blooded normative theorist, or he embraces naturalism and the greater role of forms of life and other social, et cetera, and so forth. And at the end of the day, Dworkin, at the end of the day, becomes much closer to Bernard Williams than he actually thought he was. And then he either sticks to being, if he sticks to legitimacy, he can actually keep himself as a hedgehog. But then if he actually embraces naturalism, he becomes a fox that is high on self-deception. Either one of those two things. So,
okay. So first, first, thank you for staying, especially if it's after midnight. Where are you, if I may ask?
Actually, I'm from Brazil, but I'm doing my PhD on the UK, so.
Okay. Cool. So thanks for joining so late. So on your question. So first of all, let me read just a line or two from Taking Right Seriously. So he says, the constructive model, that's page 163 in case you care. The constructive model looks at these intuitions from a more public standpoint. It is a model that someone might propose for the governance of a community, each of whose members has strong convictions that differ, though not too greatly, okay, that's a crucial passage, from the convictions of others. Okay, so you may say, if you take seriously Taking Right Seriously, and you take seriously this passage, though not too greatly, then the whole thing collapses if you end up in maybe you'd say contemporary United States, where convictions differ very greatly, right? So it's possible. And so that's one point. So it's definitely possible to challenge him on this front. I want to say again, I can't show you the table of contents, but again, when this paper was shorter, there was another section that was planned for it. Maybe if it ends up being a book, it will be added. Here's another way in which I could, if I wanted to maybe try to have it as a book, I will, which is, after understanding Dworkin and situating Dworkin, there's a section we called criticizing Dworkin. And there, which I don't do in this paper at all, I kind of just present him. And it's definitely not because I think that, everything is airtight. And what you're saying is one place where you may well say, your story does not work for example, exactly the country that you plan to design it for, the United States. In fact, you may say, there is empirical evidence that shows that when people debate with each other, rather than getting closer, people move apart. It's quite an established finding of social psychology. I can, if you want one place that summarizes this scholarship, Cass Sunstein's book, Going to Extreme, in the first 2 chapters, it summarizes the psychological literature on this. And this surprised people, because the whole idea of participatory democracy is that we come together, we see each other's side, we see the other side perspective, and we come to some kind of agreement, right? Doesn't happen. The opposite happens. So you might argue that exactly because the US is premised on something like this idea of participatory democracy, deliberation, debate, constant debate, it actually led to what you see today, which is a deeply conflicted society in which the left and the right, are kind of moving apart. Whereas societies like, for example, the UK, where there's less public discourse of this kind. I'm not saying there's no heated public discourse in the UK, but courts, for example, don't participate in that political discourse. It's different. And I lived in both countries, and I definitely can tell you that it feels different. Then actually maybe the kind of the UK approach, where, as I said, the British judge, Lord Hoffman, says to Dworkin, he mentions Dworkin. He says, Dworkin can have his debates with his taxi driver and at his dinner table. I don't want this. I want some kind of solution to the problem that just resolves it. So you could criticize Dworkin by saying your approach will actually make things worse, because it will actually encourage people to move away from each other. And so if your assumption is, as I read out for you from page 163, is that people don't differ too greatly, it will end up, it will undermine itself in the end. That's, I think, a very solid point against Dworkin. And so I think you may be onto something here, that if you, as a practical difficulty with Dworkin's approach, with the attitude of let's debate everything, let's deliberate everything, it's not working. So that's one thing. I want to, just because I kind of said Dworkin is kind of a naturalist, I want to qualify this, and is obviously in Justice for Hedgehogs and Justice in Rogues, he said some things that are definitely not naturalistic. He says the domain of fact and the domain of value are 2 separate domains. This is something that naturalists like myself cannot accept. So I want to say Dworkin in some respects is not a naturalist, but he has some things that I, as a naturalist, can actually welcome, right? So that should be clarified. In terms of, does he end up being close to Bernard Williams? I'm not, I think, I don't know enough to answer this confidently. I can tell you that they were actually very good friends. So here's a personal story, just like Thomas's. So in the very first paragraph of my paper, I say, I saw him present papers a few times. So when I was at Oxford, John Gardner organized some joint sessions with Dworkin, who by then was at UCL. And so the first session was at Oxford, and we go and Dworkin talk. And then there's this elderly guy who sits in the background and asks a few questions. And he speaks very, very eloquently and asks very smart questions. And I didn't know who he was because I was just, starting my time at Oxford and so on. And in the end, I go to John and say, who is this old guy? Says, this is Bernard Williams. And so, yeah, so they were actually very good friends. And so it wouldn't surprise me. It doesn't mean that they necessarily agreed on everything, but it wouldn't surprise me if they were quite close on these issues. But it's sort of not a good response, but that's what I can give you right now on this. So yeah.
Thank you. Let's hear the last question. Then I have a just 20-second quote from the working that I will read to finish.
In the end, just
Sophia, yeah, just in the end, yeah. Okay, Sophia, please.
I have a small comment and a question. Small comment, I actually want to, in defense of Dan Priel about boundaries of his research and Gadamer, etc. As I think we should be very accurate when we choose the field of research of Ronald Dworkin, because he mentioned even legal phenomenology. So should we research then Alfred Schutz and Husserl maybe? So if he used his footnote as an maybe alarm for us to research this field, it's not an alarm actually, because phenomenology, it's not an essential part of his legal philosophy and philosophy at all. And my question actually about connection between Dworkin and legal realism, as I understand, a lot of legal realists accept legal discretion, sorry, and don't accept so if I'm okay, yes, I'm here. And Ronald Dworkin accepts this approach of one right answer. So there is a great distinction, according to Dworkin, between legal realism and his interpretivism. So can we call him a legal realist if he accepts only one right answer?
Okay, so, okay, on the first question. So, I mean, I will not stop anyone from, trying to find interesting links between Dworkin and Gadamer, or Dworkin and Schutz, or Dworkin and Habermas, and that's fine. I mean, he does mention Gadamer. I once heard, again, a personal story, I once heard Raz kind of say something kind of denigrating. He says, oh, the footnotes or the endnotes that people wrote for him. So suggesting that he didn't write those endnotes, where he mentions, if you look at Law's Empire, he says in the beginning, I didn't write the endnotes that are just citations, but I did write the long endnotes. So I think he did write this. I mean, I'd like to think that. So there is a little bit of a reference there. It's not very serious. It's just one page, right? Page 420 of Law's Empire. It's not deep discussion of Gadamer, just like there's no deep discussion of anyone else. That's part of what I'm saying in the preface. But there's something there. That's, I will not stop anyone from doing this. It's not what I do. On legal realism. So here, it's not in this paper, it's in the paper in the works on legal realism. So let me read you one sentence that was written by Carl Llewellyn. So he says, even if a trained lawyer believed himself to be totally free, only very rarely would he be able to loosen himself from these constraints, and then to a limited extent. So he says, lawyers and judges are constrained, and even the judge who thinks of himself as not constrained is really constrained. That, if you didn't know, if I read this out to you without telling you this comes from Carl Llewellyn, you would not think this is Carl Llewellyn. Don't we all know that the legal realists believe that judges can do whatever they want? No, the traditional legal realists did not believe that judges could do whatever they want. That's, you know, I don't want to say don't read Leiter on legal realism, because it's not just him. It's really, there is a view of legal realism.
I thought that it depends on doctrine of stare decisis, and that's it. And it's not like...
But it's more than this. Leiter is Llewellyn, in this passage that I read out here, he responds to the claim or to the view associated with the free law movement that judges are completely free to do what they want. And he says, no, they're not really free. Even if they think they're free, they're really constrained. So now, this is not exactly the same as the right answer thesis. That's true. This is not exactly the same as saying judges don't have strong discretion. But it's much, much closer. It's much closer because it says, look, judges are never, lawyers are not free, and even when they think they're free, they're not free. So they are always constrained. And that sounds quite similar to Dworkin. Now, about the right answer thesis. So this, again, I hate to say, maybe you read an older version, but if you look at the SSRN version, I made, okay, let me share my screen one last time because I want to show, oh, yeah, okay, let me see if I can find this quickly. But there was, in one version of the paper, there was a whole section dedicated to the right answer thesis, which was all intended to show that, okay, let me share my screen one last time. Yeah, okay. So you see, here's a section. If Dworkin held these views, how can we explain what is possibly his most famous idea, the so-called right answer thesis? And there's a whole section dedicated to explaining what Dworkin meant by the right answer thesis, which I argued is not what most people think it is. So I then dropped it. And then I gave this paper to someone and he said, no, you should put it back. So I kind of compromised. I didn't put the whole thing back, but I extended it. So there is now more about the right answer thesis, which argues, again, that the right answer thesis is not as radical or extreme as most people think it is. It's much more attenuated. It's much weaker than most people think it is. And that, again, puts the difference between Dworkin and the legal realists, makes it smaller. It doesn't necessarily mean it's exactly the same, but that's still fine because, like I said, they don't need to, for them to be interesting in similar in interesting ways, they don't need to be identical. Just like Raz and Dworkin, Raz and Hart and Kelsen, who are all considered leading legal positivists, did not think exactly the same on many things, right? So I don't think you have to say that they have to agree on everything for them to be similar in interesting ways. So that's it. So if you do want to see my discussion on the right answer thesis, the version that's on SSRN, which you can download if you haven't, does discuss this. So I try there to say the right answer thesis that Dworkin believed is not a metaphysical claim, right? Again, it's in line with the idea that Dworkin did not believe in metaphysical truths. It's, as he said, it's an internal claim. It's a claim about how we should understand how we should interpret the discourse. And if it's understood in this way, I think it puts him much, much closer to the realists than you might otherwise think. So that's my response.
Well, thanks, Dan. I think that you should make the paper into a book. And you should spend some time saying that the Dworkinians are just as guilty as the positivists of the fallacies that you point out. Hershowitz, Stavropoulos, and the other guy, Mark Greenberg, above everyone. I wrote 40 pages to say that. And Mark Greenberg is the worst. Is definitely the worst. The people in philosophy. The people in philosophy are guilty of the same charge when they talk about moral realism. Yeah.
So let me say about this. So your paper, if you now download the SSRN version, I cite your paper because I do talk now about how Mark Greenberg misrepresents Dworkin. I don't think he's the worst. I actually think Hershowitz is the worst, but never mind. I do now have added a discussion in a footnote more about Mark Greenberg, and I cite your paper showing at length that Greenberg attributes to Dworkin this metaphysical view about moral realism. So you're in the paper now.
Thanks for this. Exactly. Thanks for this. We are in agreement now. Yeah. One last thing. I mean, let's just finish it with Dworkin, okay? I think that you will like this. I don't know if you remember this quote, but here's one of my favorite quotes from Dworkin.
Okay.
Can you see it?
No. Now, yes.
Yeah.
Yes.
How should we classify the independence thesis? In what philosophical pigeonhole does it rest? Is it a kind of moral realism or constructivism or even anti-realism? Is it itself a no-moral metaphysical theory or a quietist or minimalist theory that just ignores rather than really escapes troublesome metaphysics? None of these labels fits exactly or exactly doesn't fit, because each is stained with the mistaken assumption that there are philosophical questions about value that are not to be answered with value judgments. Please forget pigeonholes as you read this book. Thank you very much for them. We learned a lot from you, and I think that there are very few people in the world that understood Dworkin just as good as you and Thiago, who I chose to comment you today. It was a very nice evening. It's a kind of refreshing after reading so much metaphysics. When you read something different, you kind of feel your mind free from the semantic sting, to put it in Dworkin's unhappy. Thiago gets upset when I said that Dworkin doesn't have a semantic theory, because he actually does have one. But I think that we learned today a lot, and I thank you very much for sharing your time and your work with us.
Thank you so much for coming and staying. It was great. Thiago, thanks for your comments, which were exceptional. And I enjoyed it a lot. So thank you for organizing this as well.
Thank you very much. And bye. Stay well, you all. I think I will end this session now.
Stay well.
Bye-bye.
Okay, bye.
Bye.